right, good afternoon. My name is Evan Gessner. I'm an attorney down in Lexington, South Carolina, where I handle civil rights claims, tort actions, property damage, much other sorted stuff as it arises. It's my first year judging a national level competition, though I've been involved with the state We the People here for probably about 12 or 13 years now. So I'm very excited to be here and looking forward to your presentation.
And my name is Francine Engel, and I am a judge from the state of Maryland. I am a political scientist, and I focus on American constitutional development. And I currently work with the Maryland Council for Civic and History Education.
And my name is Jocelyn Broman. I am an alumni of the program. I competed at nationals back in 2006, like several lifetimes ago, it feels like. I currently work on Capitol Hill for Representative Don Young of Alaska. And I've been on Capitol Hill for about 5 years with various different offices. And that was after I went to law school. So you have another attorney on the panel that you get to have fun with. So looking forward to all of this. Thank you.
Good afternoon, judges. We are Unit 3, and we'll be discussing how the Constitution has been changed to further the ideals contained in the Declaration of Independence. We'd like to thank you all for being here this afternoon, and we'd also like to thank our coaches, Judith Miller and Jenna Billups, our mentor, Yana Paris, and our teacher, Sadie Adams. My name is Claire.
My name is Ellie.
My name is Matt.
And my name is Miley. Thank you. We're now ready for your question.
We got Unit 3, Question 1. Oliver Wendell Holmes once said, "I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states." What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? Go ahead and begin whenever you're ready.
Justice Holmes was correct that it's crucial for the Supreme Court to have a check on the states to maintain the Union, but he understated the importance of a check on federal powers. Judicial review is the best way to hold both state and federal officials accountable. Without such review, the Union would truly be imperiled because the political branches could violate the Constitution with impunity.
Overall, judicial review has had a greater effect on state power than on federal power. State power has steadily decreased, while federal power has gone through cycles of expansion and limitation. Early on, McCulloch v. Maryland broadly interpreted what necessary meant under the Necessary and Proper Clause, thus expanding congressional powers. However, after the Civil War, the court began to limit Congress. For example, in 1918, in Hammer v. Dagenhart, the court struck down a law banning the interstate transportation of goods made with child labor, holding that the Commerce Clause did not give Congress the power to regulate working conditions.
Then, after striking down much of the New Deal and facing President Roosevelt's court packing plan, the court began to uphold the legislation, thus again expanding federal powers. For example, in Wicker v. Filburn, the court decided that the Commerce Clause allows Congress to regulate anything that might affect interstate commerce. Between 1937 and 1995, the court didn't find a single federal law to be beyond Congress's power under the Commerce Clause.
In addition to its effect on federalism, judicial review is counter-majoritarian because, as the scholar Alexander Bickel put it, quote, "When the Supreme Court declares unconstitutional a legislative act, it thwarts the will of the representatives of the actual people of the here and now. It exercises control, not on behalf of the prevailing majority, but against it," unquote. Judicial review may thwart the will of the legislature. However, because of partisanship and constitutional provisions that favor the smaller states, it cannot be said that legislators, or any other elected official, completely represent the people's will.
Although judicial review is counter-majoritarian, it is still the best way to protect the Constitution. The current majority of the people may be driven by the passions of the moment, while the court's adherence to precedent forces it to focus on the long-term common good. Additionally, as Alexander Hamilton said in the Federalist 78, The judiciary is the quote, least dangerous branch, unquote, because it cannot enforce its own rulings.
The court is also constrained from abusing its power by the case and controversy requirement and its self-imposed limits involving mootness, ripeness, and political questions. Finally, simply because an institution is undemocratic does not mean that the decisions coming out of it will be undemocratic. Without the check of judicial review, the other branches could violate the Constitution, regardless of whether it was supported by the majority.
While judicial review may be the best option, it has concentrated too much power in the court. Article 3 grants Congress the power to define the court's appellate jurisdiction. Congress should codify the court-created doctrines of mootness, ripeness, and the like. It should also use jurisdiction stripping more frequently to confine the court's review of specific laws as it did with the Norris-LaGuardia Act, similar to Section 33 of Canada's Charters of Rights and Freedoms, which allows Parliament to declare that judicial review cannot be used on a specific statute.
Congress should also be able to override Supreme Court decisions through a supermajority vote if it can explain how the law is constitutional. This would be similar to the British Human Rights Act of 1998. Together, these limits would help restore balance among the branches and levels of government. Thank you. We're now ready for your questions.
Okay, thank you. Let's see. Bear with me, I was just finishing my notes. I think y'all had commented about the court having a little too much power. Let me ask, how does differing theories of constitutional interpretation affect judicial review? I'm interested to hear what you have to say about that.
Differing theories of constitutional interpretation cause, obviously, different interpretations of the Constitution can influence how judicial review affects the other branches of government and how much power the court seeks to claim. However, regardless of differing constitutional interpretations, the lack of check on Supreme Court power is still the same.
Additionally, no matter the Supreme Court justice's opinion, they all, as my teammate said, have a very few limits on their power. Besides their own court-created doctrines, those aren't federal law, so they don't have very many limits on what they can do with judicial review.
Okay. I think at least one, if I recall correctly, one of y'all had said earlier, or at least alluded to, that the courts, can the courts enforce their own decisions?
No, the courts cannot enforce their own decisions. And that is one of the major limits they have that sets them back from the other branches of government. However, because the courts do not have a check by the people through elections, that power is often harder to control, even if other branches of government do not have to follow it.
Additionally, this is one of the reasons that Alexander Hamilton referred to the judicial branch as the least dangerous branch, because their main power is just the power of interpreting the Constitution and not enforcing anything.
So, but your opinion is that Hamilton hasn't held true, and that actually the Supreme Court is pretty much the most dangerous branch now. So, but I'm going to push back in this way. Do we want to give this political power of overturning Supreme Court precedents to a supermajority of Congress? And why? How can that actually? Couldn't that actually institute some other majoritarian practice?
It could if we were less divided. Because we're so divided, a supermajority vote in Congress would be very difficult to obtain, and it would almost certainly be bipartisan. And so while that might cause issues if we were less divided in our current system of government, I think it's still a reasonable check because it's so difficult to obtain that supermajority vote.
Go ahead.
All members of government and all elected officials take oaths to support the Constitution and are able to interpret the Constitution themselves. Some may argue that it is better to trust a supermajority of elected officials with the check to the people than 9 unelected officials on the bench. Yes.
And in theory, I mean, judicial review is the most used, I think, interpretation tool for the Constitution, but is it the only one that we have?
Could you rephrase the question?
Yeah, don't we have like coordinate branch review? Can't like the executive branch and the judicial and the legislative branch say what they think the Constitution means? So shouldn't we make sure that we can all the branches get a chance to have their say on the Constitution interpretation?
Prior to Marbury v. Madison, which decided the Supreme Court responsible for the power of judicial review, actually all three branches of government were responsible in some sense of interpreting the Constitution. It was only in the mid-20th century when the Supreme Court took that responsibility.
Additionally, because of the weight of being a Supreme Court judge and how important that is, their opinion, judicial review and interpreting the Constitution is their job. Like the president, for example, has many responsibilities. The court's lone responsibility is defending and interpreting the Constitution.
In addition, we now live in a more era of judicial supremacy, when the Supreme Court is the final word on the matter, as they wrote in Cooper v. Aaron, compared to one of judicial review, where all branches are able to interpret the Constitution.
Okay, so I just want to build on what you just said. Are you saying we're now kind of living in an era of judicial supremacy? And maybe we are. But you also talked about different ways to limit the court. And you talked about jurisdictional stripping. Is that seen as a check to show that they really are not a branch that possesses judicial supremacy?
Yes, that is a check that Congress can utilize to limit the effect of judicial supremacy. However, Congress very infrequently uses its power over the court's appellate jurisdiction, allowing the court almost unchecked power and allowing the court to make decisions in stuff such as the shadow docket as well.
Additionally, because of the separation of power among the branches, jurisdiction stripping is an extremely controversial subject. And because of this, jurisdiction stripping is very rarely used.
Now, what about the difference? You also sort of talked about in self-imposed requirement of avoiding political questions. How can the court tell the difference between a political question and a legal question?
I would say that that is one of the issues we have with the current Supreme Court, is the inability and the lack of clarity about what constitutes a political question versus a non-political question, and that has allowed some things that maybe should be left to the legislator to be decided by the court.
I agree with what my teammate. Oh, I'm sorry. I agree with what my teammate just said. The court actually has ruled what can be determined as political questions before. For example, in 2001, the Supreme Court case Bush v. Gore, there were issues with Florida's votes being counted, and it was pretty much left to the Supreme Court to almost choose who the winner of that election would be, and the court ruled for Bush, and that is an example of an almost political question that the court answered.
Additionally, this limit specifically, in addition, and some other limits like the limits of mootness and ripeness, can I finish my statement? Are still just self-imposed limits and are not actually enforced by anyone else and are just what the court says they should be limited.
All right, let's give the students a round of applause for their hard work and participation today. Great job, guys.
Great.
Yeah, and now we'll have some judges' feedback.
Great. All right, everyone, great job. Really, I can tell you all put a lot of hard work and effort into this. I feel this is I think the fifth round we've done today on the same question, and I'm kind of a little bit afraid that as judges we're getting trying to go a little deep into this and starting asking progressively harder and harder questions that might be beyond the scope of your curriculum. But no, I think y'all handled that well, and you know, doing a competition like this, sometimes you're going to get a question that you didn't prepare for, and right off the, you know, your first thought is, oh, I don't know the answer to that. But I think y'all handled it very well, and you just, okay, you know, this is the information on it. You know, you answered the questions. You really did a great job. You know, as I've been saying pretty much all day, one thing I look for and I like to see is when a student says something that I hadn't ever thought about as a practicing attorney now for 13, 14 years, something like that. You know, for you to say, y'all mentioned, you know, codifying the Supreme Court's self-imposed limitations. And I honestly don't think I've ever heard that brought up. And that makes a lot of sense. And I can tell you that from my experience, these self-imposed restrictions are treated as though they're written in stone, but you're right, they're absolutely not. So why wouldn't you just go ahead and make that a hard and fast rule? That makes a ton of sense to me. So yeah, great job. You all are very well prepared and really know the material. Great work.
Yeah, this is a great presentation because it was different than a lot of the other ones we've heard, with you giving us, this is where we should limit judicial review, this is how we should do it. And that's, I think that definitely changed up some of my questions of what I was asking you guys, but you can tell that your depth of understanding about both the jurisdictional issues and how it changes over time, also bringing in like how Canadians, and I think it was the British that had their changes, and how they would have, specifically with the Canadian example of how the Parliament would say that you can't use judicial review on that. That's a great example to really highlight that the other like common law systems that use judicial review, this is one of the ways that we can do that. I don't know whether Congress would like to do that. They kind of like to push things off, if you've seen the imbalance of things. Also how we like only do some things. Sometimes we don't do a lot of work. But I think that your examples for doing that and the way that you were reasoning behind it made a lot of sense. And it was really good to hear. A couple of cases that we hadn't heard before from your statement were like Wickard versus Filborn and the Hammer versus Dagenhart, to like, you walked us through like how that federal power changed and how the court kind of changed what they were doing. That was a very good discussion as well. So overall, great job. And it was a lot of fun. Thank you.
Yeah, I'll just echo what the other two judges said. One of the things that I really liked about your presentation, it was very well organized and I was able to follow it very easily. So, you know, you had a specific argument that you were making and I knew exactly where you were going with everything. So as a judge, that was really helpful to know exactly what your positions were with things, and also how you kind of went through the historical development of things, which was really nice. I really like that you brought up Alexander Bickel with the counter-majoritarian issue. And I'm really excited that you also, you know, you talked a lot about the self-imposed restrictions. And I do like the idea that you mentioned, the idea of codifying those ideas. That's the first time we've heard that from anybody. And, you know, you brought up the idea of court stripping, which I don't think we've heard it from anybody else today. So that is an excellent example to bring up. So you just did a fabulous job. Thank you so much.
Thank you.
Thank you.
Thank you.
Great job, everyone.